let's start with you, Mr. Gilroy. I've read your motion and I've read the response. Is there anything that you'd like to add before I hear from the other side and then from the guardian ad litem?
Yes, sir, and thank you for the opportunity. I respectfully submit this argument in support of my motion for 3 hours modification for Yom Kippur parenting time and against all plaintiffs' requests for relief. Our daughter was just 19 months old at the time of divorce. She's now in early preschool, and I work with the plaintiff to personally enroll Evelyn in formative extracurriculars. They include gymnastics, swimming, and roller skating lessons. Plaintiff has previously stated at our family wizard that she might not be able to make all of these to get the transportation figured out, but we successfully worked together, and I promise to fill any such gaps that our daughter might have in these types of activities. Our judgment of divorce grants both parents independent authority over routine and day-to-day decisions during parenting time. It explicitly prohibits interference from the other parent. It includes choice of attendance for special events, such as Yom Kippur, a full Yom Kippur experience, including a communal meal at a safe community gathering, serve our daughter's emotional and developmental needs, which have changed now that she is within 3. This change in circumstance since the entry of the current order, our daughter's evolving needs, and expanded opportunities for growth establish proper costs for this modification under the best interest factors. In March of 2025, Stacy Van Dyken recommended that I file this motion for the additional holiday parenting time. I genuinely believe that we could resolve a matter of just 3 hours, which may occur during my normal parenting time anyway, without extensive litigation. Furthermore, the GAL, after hearing arguments from both parties, instructed both of us that I could take our daughter to Hebrew school during my parenting time if I so chose to. Furthermore, I yielded my parenting time for that whole week during Yom Kippur so that our daughter could have meaningful time with her mother. It's a very formal event, so I wanted to make sure she had like special girl time to get dressed and get prepared for this and have time for both of them to bond. I went even further than that and said, if you want to take her on a special shopping trip, I'll reimburse you up to $100, get her a couple of dresses, a nice pair of shoes, whatever. Now, plaintiff did deny the shopping trip part of it, but it seems like she's on board with helping her getting around for this stuff. In total, my parenting reflects all statutory best interest factors. I foster age-appropriate cultural, educational, religious experience, supporting our daughter's autonomy, and I thoroughly have documented all co-parenting efforts. My legal filings fully comply with the rules regarding that everything I present is complete and accurate. Plaintiff's filings, on the other hand, repeatedly omit material facts and request authority beyond both what our judgment of divorce allows and what the GAL has recommended, including veto power over routine decisions and conditioning cooperation on demands unrelated to our daughter's welfare. These omissions and misrepresentations are in direct violation of that same rule. This isn't a first-time instance. On July 18th, lately, we've been doing like video calls between us. While our daughter is away for an extended period of time, we've been doing video calls, and that's been great. However, on July 18th at 5:39 p.m., our daughter was with her mother, and I got one such video call. It only lasted for 1 minute and 58 seconds. I was on my way to Temple to go to services. I told her daughter that. Our daughter asked a couple of questions, and the plaintiff started yelling at our daughter and demanded she hang up the phone immediately. I didn't intervene. I didn't stop. It wouldn't have been appropriate at that time. Our daughter doesn't need to hear us arguing, more so that's already happened. For Yom Kippur 2025, all of my parenting time falls under the existing continuous parenting time with our existing judgment of divorce. Plaintiff caused an issue with that and said that she needed to have a day in trade in order for me to get a full overnight for Yom Kippur, as the JOT already states. This has come long after we, both of us, successfully applied the same continuous parenting time principle for Thanksgiving 2024. In the same conference call in March 2025, Stacy Van Dyken warned us not to do this type of thing.
So let me ask you this, Mr. Gilroy. Your motion, and I read it pretty extensively. and this is what I know, that you have filed a motion for parenting time. And the last parenting time order was the party's judgment of divorce dated March 25 of 2024. And your request, very simple, is that parenting time be extended on Yom Kippur on the second day of the holiday past 6 p.m. for the communal meal. And the only change is that from the time the order was entered in 2024 until now, the child went from age 2 to age 3. Is that correct?
Not entirely, sir. I also moved between, at the time, like right around when we were entering that divorce, I was moving from Hickory Corners, Michigan, a little over an hour away, to Granville, Michigan. So that changed as well. We were trying to finalize a lot of those things. I was moving around that same time period.
Okay, but that really has nothing to do with this motion. It's requesting that I add 3 hours to your Yom Kippur, that it's not 6, that it's later. I'll hear from Miss Martin, and then I'll hear from Miss Van Dyken. Miss Martin?
I wasn't finished, Your Honor.
Oh, we're not going to try this case right now, Mr. Gilroy. I think I've heard enough on this. I've heard enough on this motion.
I just wanted to present that we've already agreed. We agreed in writing that I would get the 3 hours.
Well, that's why I'm off to Miss Martin. Right?
Sorry, apologies, sir.
Because if Miss Martin says that, then this motion's done, right? Miss Martin.
Hello. Specifically for Blake's motion, for this year only, 2025, I did agree to the extended 3 hours. Part of that is the continuous parenting time. I may have misunderstood that. Also, to abide by our current temporary order that's in place that sunsets in October. I'm also trying to be reasonable, even though I don't personally agree, which is probably evident from everything that's been filed, about assigning our daughter a religion. I'm also not, I'm aware that there has to be compromise here. And so that was my compromise. So I agreed to it in writing for this year only. After I said that is when I received Mr. Gilroy's response stating that now he wants it to be permanent and forever, and then if I do not sign a modification, a stipulated order, he would be filing to take me to court, which is why we're here. And I just said, I am not ready to say that this should be forever. The child is only 3. I've agreed to it temporarily this year. Let's just see and work together how this goes in the future. And you know, I don't believe that the child going from age 2 to age 3 has proven that threshold as to a change in circumstance. That seems like a pretty high bar, and from what I've been told, and just listening to your previous court proceedings.
Yeah, but you lowered the bar. You agreed to it.
Well, I had to, Your Honor. We have a temporary order in place.
You had to agree to it?
Well, otherwise I would be in violation of our temporary order.
Ms. Van Dyken, can you shed some light on this, please?
It's my understanding that Ms. Martin agreed to this year and this year only. This was, as the court stated, this was not an easy case to resolve at the judgment of divorce. Quite frankly, I believe my words were, you guys either need to figure this out or dismiss your divorce and start all over. So there was quite extensive discussions about religious holidays for Mr. Gilroy. And in the judgment, if that was going to be considered the additional 3 hours for a communal meal, it would have been in that judgment of divorce. We specifically listed the specific holidays. There was extensive discussions. I applaud the parties for working together and trying to resolve some issues, but it was clear to me that she had only agreed to this year.
Okay. Then we'll will you be preparing the order on this, Ms. Van Dyken?
Yes, Your Honor.
Then I will grant the motion for Yom Kippur 2025 only. Additional years will be by agreement of the parties, or if no agreement, they shall submit to mediation on that issue. Now, the second, more probable motion is the what I consider, and I've read it. I take it you got a copy of that too, Mr. Gilroy?
I did, Your Honor. You mean the one I responded to, Your Honor, or something different?
No, the motion that Tanya filed and you filed a response to.
Yes, sir.
Okay. I've read your motion, and quite frankly, I really cannot give the parties advanced guidance on whether a particular activity violates the religious neutrality provision in their judgment. And I won't do that. Obviously, it's an interesting scenario. And I know, Ms. Van Dyken, I think, according to the information, it was you that that insisted on that provision. Is that accurate?
That is accurate, Your Honor.
Okay. Well, I can give you some guidance on that if the parties are willing to listen to that. So I'm quoting from a case called Fisher versus Fisher. So if you ever want to write that down, it's found at 118 Michigan Appeal 227, a 1982 case. And I'm quoting from the case, and it says as follows: once the purely secular decision of custody is made, okay, which it has been in this case, the parties made it, the court may not interfere with the religious practices of either the custodial or non-custodial parent, unless, of course, those practices threaten the children's well-being. The court may not order the custodial parent to educate the children in a particular faith, just as the non-custodial parent's right to pursue his or her religious activities and to involve the children in those activities during legal visitation periods cannot be violated. That was the case of Hilly versus Hilly, and that was out of Alabama. So religious neutrality, what it really means is the refusal by a court to intervene in the absence of a showing of harm to the child reflects the protected nature of religious activities and expressions of belief, as well as the proscription, which I'm sure Ms. Van Dyken was getting at, against preferring one religion over another. So that's what the religious neutrality clause means. It means that I can't stick my nose into either parent's raising of this child in their particular religion unless there's an allegation of harm to this child or children. So that is really what this amounts to. Now, I will tell you that I don't know if the parties will ever be on the same page, because quite frankly, I've had cases where parents have taken children to temple and also to the cathedral. And that's the way it works. And then at some point, either the parties say, you know what, this is not doing anybody any good. That usually works when the parties are in a little bit better spot than where this case is. Or the child will somewhat say, hey, look, I'm interested in being confirmed. I'm interested in going through the Jewish faith, whatever. But this court cannot pick and choose sides. That's what Ms. Van Dyken was referring to with the religious neutrality. Ms. Van Dyken, is that about spot on?
About spot on, Your Honor. To clarify as well, it was also about not listing the child as any religious affiliation on any documents as well.
Yeah.
And that was in addition, so.
Yeah, I mean, so when the child goes into the hospital or something, or to the doctor, and they go religious preference, the parties can either list them both or put non-denominational, whatever they want to do. But that's where the religious neutrality goes. So that's how I can best answer your motion, Ms. Martin. I can't give you any advance directive as to whether this or whether this or whether this would violate that clause, because number one, it hasn't, there has to be another link to it. And it would be threatening a child's well-being. And I don't know how any religion could ever threaten a child's well-being, but go ahead.
I appreciate your answer to help Tanya clarify things. And I'm not trying to be overly redundant. And I realize that I just, around schooling, whether it's religious school or not, right? We have to be on the same page under the terms of joint custody.
Exactly. But I will tell you this, and this is something you both might have to realize, is that after a few of, let's say, school issues, let's say doctor issues, therapist issues, these types of things, after a few of those, I am going to be in a position of having to find that one of you should not have that authority anymore. And that authority would be exercised by either Miss Martin totally or Mr. Gilroy totally, and not as joint custodians. And that not only involves religion, that involves doctor's appointments, therapy appointments, the ability to participate, to get all the records, all that stuff. And that's a very, very dark road to go down, but unfortunately one that I can really see is on the horizons for both of you, unless you two make some sort of concerted effort to get on the same page with this stuff. That's all I can tell you. But you're right, they have to agree on major decisions. But religious, going to a particular church or going to participate in religious activities is a decision that a custodial or that a visiting parent has, just as much as you have that. That's not anything that can be decided. So I'm all set, Ms. Martin. I can't keep going through question and answer sessions. Can you prep that order, Ms. Van Dyken?
Can you, I just want to, there was one other issue Ms. Martin raised about service, and I can direct the parties to the court rule with regard to service and our local administrative rule as to service via email.
I didn't, yeah, I thought that was.
It wasn't presented before the court, but it was an agreement we made, Your Honor.
Okay. All right, Ms. Van Dyken, will you prepare that?
Yes, Your Honor.
Ms. Martin, is this going to keep going on and on and on and on?
No, Your Honor, I'm just trying to ask about the email thing. Is it a 7-day or a 9-day notice?
Email is 7 days.
Okay.
Oh,
thank you.
yeah. And believe me, if you two need to, if this case is ratcheted up that high, then you have bigger problems than I can figure out. We're adjourned. Thank you.
Thank you.
Thank you, Your Honor.